Okay, well, looks like I'm streaming now. So what I'm going to do here quick. Today is February 12th on my case, so that's what today is now. And I need to run over to my video editing, my system here quick, so I can see how this I'll give you a quick update on what's been happening here so far. So, oh, that's not working. I must have to go to my channel. Hold on a second. Videos. Go to my videos page live now. Okay, there we go. I'll shoot my audio sound, my background space stuff is on. Hold on, let me turn that off. Audio sound, my background space stuff is on. Hold on, let me turn that off. There we go. Now I have to mute this. There we go. So now I got an audio loop going on for a few seconds here. Okay, so in the last live stream that I did, I was talking about how my the judge had submitted the conference. Okay. Motion of continuance conference is ordered. All attorneys. Okay. So, what happened after I filed that thing? Okay. Well, what happened after that is defense came back with a bunch of stuff, but I wasn't scared. Okay. First thing that they filed on what day is this? It was the 28th, I believe they filed it. They filed it on the 28th. Now the first thing that they filed when they walked in was a motion was a notice of appearance. Now, so far I've been up until this point I was dealing with one attorney, okay? I was dealing with just the child support attorney. But now he brings in a special assistant attorney general with the state for the Department of Health and Human Services, DPHHS, Department of Health and Human Services. So he brings in another attorney, which is a notice of appearance. So that was the first thing that they filed. The second thing that they filed was which is what I kind of anticipated them to do anyways, because they always do this, was a motion to dismiss. Dismiss the case, Judge, because this guy's dumb and he's just an idiot. He's trying to come after us. Stuff like that. First thing that they file is they motion to dismiss. Then after that, after this, comes the brief. The motion to dismiss comes now, the state of Montana, by and through its attorney, Mr. Quinn, and moves the court to dismiss the Title 40 Collection Franchise Child Support Enforcement Division, CSED, from Mr. Sanem's claim. 42 U.S.C. 1983 claim pursuant to Rule 12b. The undersigned has contacted the plaintiff as required by Rule 7.1, and he opposes any motion to dismiss. A brief in support is filed contemptuously, which means along with this. Federal Rule B6, or Federal Rule B, he didn't say the specific one, but he does here. The brief. The state of Montana, in support of its motion to dismiss pursuant to Rule 12b, submits the following brief. Plaintiff's complaint asserts a cause of action. Title 4D, Collection Franchise Child Support Enforcement Division, under 42-1983. Complaint, paragraphs 25 through 74. However, the state and its agencies are not persons for purposes of 42-1983's William versus Michigan. Additionally, the plaintiff has not complied with the service requirements of Rule 4J2A of the Federal Rules of Civil Procedure, as it does not appear that the Chief Executive of Montana has been served as of date of this filing of this brief. And that's right. The Chief Executive of the state is the governor. I didn't see why I need to serve the governor or anything. Accordingly, pursuant to Rule 12b, the state of Montana and its Department of Public Health and Human Services Child Support Enforcement Division must be dismissed from Mr. Salem cause of action for failure to state a claim upon which relief can be granted, failure of process, or lack of jurisdiction. So there's three things. Three things that they're asking the judge to knock my case out. But I came back with this. Yes! I came down here and I started typing this shit up right away when I got this. Now this was interesting. On each one of these filings, they have a certificate of service telling the court that they're going to serve these paperworks to me via the U.S. mail. See the number 1 mark there? U.S. mail. All three of these type of documents, I never got them. They never got sent in the mail. When I went to go file this, I asked. Now, when I walked in there, when I called them up on the phone and told them that they're going to be open on a certain day, they were like, "Oh yeah," and I says, "Okay," because I see on the docket that the defense has dropped some stuff off, so I'll be in there to get prints, copies of it. She says, "Oh well, we already have it on here that they're going to send it to you in the mail. They have to send it to you in the mail." I'm like, "Oh, okay. Well, alrighty." So I hung up. I then left and I went to take the kids to a speech class. It's a home group speech class. And then while we're coming back into town, I thought, you know, I really should go get copies at the clerk's office. I really should do that. I don't know why, but I should. So we went there. And when I got in there, when I walked into the clerk's office, one of the clerks in the back was just like, she was talking to somebody and she looked out at me and she was like, and then she like waved her hand up like in our direction, like, "I told him he didn't have to come in, blah, 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 blah," or whatever she was saying. So I walked up there and I says, "Oh yeah," I says, "Yeah, I thought, no, I'll just come in and get copies of this section because I don't know how long it's going to take." And she says, "Well, it says right here that they are going to send it to you in the mail." And I was like, "Well, I just want copies just in case." "Well, it's going to cost you." I'm like, "Okay." So I went to pull my money out, come to find out that they don't offer change back. This clerk's office doesn't offer change back. And all I had was a 20. So she got me the copies of all of this stuff. And then I went to give her the 20 and she was like, "Oh, well, no, we can't give you change back." I was like, "Oh, shoot. Well, I'll bring in the change later. You know, I'll pay for these, you know." Well, anyways, I'm glad I went down and got these, because today is the 12th and I still haven't gotten these things in the mail. So defense, the child support attorney and the Department of Health and Human Services attorney told the court on this document that they were going to send it to me via mail, and I never got it, even to this day. If I would not have gone down and gotten this paperwork, I would not know about it. So I came back with this. I better put this stuff back in here. After they filed that rule to dismiss, I then filed this. I wrote this up that night. See, it's even got the clerk stamp on it. Received it. Okay. On January 28th, a motion to dismiss was entered into this case by Mr. Quinn, attorney for CSED. The grounds for the dismissal were 3 separate issues: lack of jurisdiction, failure of process, and failure to stake a claim in which relief can be granted. Jurisdiction is correct in this case. The first 6 pages of the initial complaint establish this. The state of Montana and Department of Health and Human Services is not part of this case. Only the single and separate services, only the single and separate collection service, CSED, which is contractually created between the state and the Federal Office of Child Support, The Doe defendants are being sued in their individual capacity. Now, in that case that guy cited, the states are immune from suit when they're operating in their official capacity, not individual capacity. Doe defendants are being sued in their individual capacity. First page of the complaint shows this. Defense cites a case, Will versus Michigan Department of State Police. This was a case decided by the United States Supreme Court in which the court said that states and their officials acting in their official capacity are not persons when sued for monetary damages under the Civil Rights Act of 1871. However, no state or state officials are being sued in their official capacity. If plaintiff was to sue the state or DPHHS, they would not have immunity either, as the Constitution of Montana clearly says that the state has waived its immunity to suit, Article 2, Section 18, way back in 1973. 42 U.S.C. 1983 authorizes claims against those officials in their individual capacity for compensatory and punitive damages. Although the 11th Amendment limits official capacity claims against state officials to prospective injunctive relief, it does not affect damage claims against those officials in their individual capacity. Doe defendants are being sued in their individual capacity. CSED is being sued in its official capacity because CSED is the operating corporation, partnership, and representative of Doe defendants. Failure of process. In constructing this case, now this is the second one, where he says, I failed the process. Send paperwork off to the governor's office. Failure of process. In construction of this case and reviewing the Federal Rules of Civil Procedure, plaintiff did not deem it necessary to notify the governor, as the CSED is created by contract and not an original creation of the state's legislature. This will be proven in discovery when CSED files its Federal Rule of Civil Procedure 7.1, Corporate Disclosure. However, plaintiff will send a copy to the governor within the week. Plaintiff has sent a copy of the complaint to the Attorney General certified mail pursuant to Federal Rule 5.1. See Attachment 1. And Attachment 1 is the proof of service, the little thing that gets sent back to me after it gets delivered. Little green card. Plaintiff has also placed in an attachment showing how the CSCD is structured in Montana. Attachment 2. This is a handy-dandy little block diagram that I made to show them how child support works within the state. Yeah, so that way the defense understands how their boss works. Number 3. Failure to stake a claim upon which relief can be granted. Well, now, a complaint should not be, now this is quoting a case, a complaint should not be dismissed for failure to state a claim unless it appears beyond doubt that the plaintiff cannot prove no set of facts in support of his claim, which would entitle him to relief. I've got 14 cause of actions in my complaint. To establish a claim, to establish a case under 42-1983, plaintiff must allege certain elements. 1. The action occurred under color of law, statutory law, state law. 2. The action is deprived of a constitutional right. The action is a deprivation of a constitutional right. The constitutional right must be clearly cited. Each cause of action has these elements. Plaintiff requests that the motion to dismiss be denied. Yeah. Okay. So then I filed that. I went down and I filed that. When I was talking to the lady there, it was a different lady. I told her, I says, yeah, I says, this paperwork here that I got came in here the other day to get, they said that they were going to send me this paperwork in the mail, but I never got it. Is there some type of complaint form or something I can fill out that says that they're not doing their job? They're not sending me stuff in the mail like they said they're going to. So I was thinking about doing that, and she goes, well, if they have it listed in there that they're going to send it to you in the mail, and they've got it on our record, and they haven't done it, and you haven't gotten anything, then, you know, it's kind of up to you. That's not very good, you know. That's not good for them to be doing that. I'm like, yeah, I know. I said, but I wasn't too sure if you guys had like certain complaint forms that I could fill out and say, oh, well, these guys ain't. She goes, well, you probably could. And I go, yeah. But she goes, it's kind of up to you. And I go, no, I won't do that. Because I'm sure there's, and I didn't, because this is the first time I've ever done this. I have nobody helping me out with this. So I don't know what to file, when to file, or how to file it. All I can do is look at these rules and follow all that stuff. So yeah, so that's what I'm trying to do here. And yeah. And I know, I mean, just looking, he even pointed out in their motion to dismiss that they're in compliance of the local rules, where the text should be like Arial, and it should be 14 size font. And I look at all my stuff, and all my stuff's in 12 size font, and it's not in Arial. I put all my text in like real fancy, and not in real fancy, but slightly fancy, fancier text, and it's all 12 points. So everything's small. Yeah. So that's where we're at right now. And now apparently I have to write up a meet and confer. See, the judge I haven't heard anything back from the judge, and the judge has 14 days to answer to see whether or not this complaint can go through. if the judge will accept the case. I don't see why he wouldn't, especially after issuing out this meet and confer thing. The case is open. Where is it? Yeah. Docket 6. See, this is where we're at right now. Let me pull this up so I can show it to myself off into the future. Hi, Nova. Hi, Ashley. Kitty, kitty. Oh. Source, screen capture, monitor capture. Desk 1, desk 2, desk 2. There we go. Okay, so let me move over here a little bit, make this a little bigger. Ah, it's going to cover up my face. Okay, so cursor. So we got one there, got the filing, have all this right here. See, it's kind of weird that I sent child support the summons. I sent off the constitutional state statute challenge on the 17th, 7 days later. And the judge then issues out the pre-trial conference order. He issued this thing out before. You guys see that? Yeah. See the wiggle of my mouse? He issued this out way before child support had an opportunity to ask to dismiss the case. You know what I think's happening? I think my case is, honestly, what I think is, I think my case is written so damn well that the judge clearly sees that there is no way that the state can, that child support can turn around and say, "Oh, please dismiss the case, Your Honor." He's probably looking at the thing going, "Shit, he's got all the elements here." See, all this stuff right here comes from defense. Notice of appearance, motion to dismiss. This is the brief to the motion to dismiss. Text order, the motion of plaintiff requests. Oh, docket 7. Yeah. See, down here in docket 7, this is where I asked the judge, if you remember from my other live streams, this is where I asked the judge that if defense doesn't meet the time requirement to respond to my summons, then please grant them an additional 21 days, because this attorney that I was taking on, Mr. Quinn, this attorney, this guy, he's trying to be a judge, and I looked it up, and there was a lot of stuff going on back then, so I kind of figured that maybe he'd probably forget about the case. So I asked the judge to extend child support 21 extra days so that he could respond. Well, this right here is where the judge finally, once they did respond, the judge says, the motion of plaintiff requesting a continuance, docket 7, is denied. So the judge denied the 21-day extension. That's what that is. That's okay. This matter shall proceed in accordance with the schedule set forth on docket 6, so ordered. And then I went in, and once I started realizing that I can't really trust these attorneys to send me the paperwork through the mail, then I had better go in there to the clerk's office, the federal clerk's office, and set up. They would send me copies of all documents that get entered into the case via email. So yeah. So that's what 13 is here. Consent to electronic service. And then 14, response to the motion to dismiss, where I've got attachment 1 and attachment 2. That's where that is at right there. Okay. And then the notice by me, this right here is the notice that I sent out to the governor's office. So I did comply with what they asked me to do, and I hadn't sent it out to the governor's office yet. So just, so just because you don't meet the deadline or you haven't done something, that doesn't mean you still can't do it. Sometimes if you overshoot something by a big massive deadline, something you blatantly forgot, you have to ask the judge if it's okay for you to do it. That kind of thing, yeah. So, yep. All right, where's my dang mouse cursor? That gets you screwed up, don't it? Okay, my mouse cursor's over here, and it's right there, so which one is the real one? But, and today, like I said, today is 2/12, and every day that goes by that I don't do something on this case, I get like freaked out, and it's like I want to get involved in it, do but there's Oh, I also got this. I finally found the local rules of civil procedure, so I'm going through this. There's local rules of federal United States District Court for the district of local rules of procedure. So it's got both civil and this section right here that's got the little marks in it. All these pages right here. This is criminal, so I completely avoid that. I've got it all clumped together so I don't accidentally start reading it. I don't need to read about criminal activity and all that kind of crazy. Yeah. So now I'm just kind of going through that, and it's just like I'm trying to find examples on how to write up preliminary stuff, how to write up this other stuff that they want me to do. Meet and greet, meet with the attorneys and talk to them, which I really don't. Because you know what they're going to do. I know what they're going to do. They're going to sit there and fucking try to hound me and gain jurisdiction, like get me to agree to it and all that kind of shit. Because that's the kind of fucking people they are. They operate in the guerrilla tactics of family law. So these people, they're not ethical people. Yeah. Family law is not a good thing. Yeah. So I really don't know what to do right now. I have until the... You know how it says April? April 11th is actually my date to be in front of the magistrate for the pretrial conference. Previous to that, 30 days before that, which is March 14th, or maybe it's 21 days, something like that. March 14th is the date that I have to have at least something written up. Oh, at least something written up to submit to the courts on what's kind of going on right now between me and the attorney. But I'm going to point something out here that I did kind of notice in one of these papers here. And you might, I don't know, maybe it's just me thinking that I've got somebody on the inside helping me out or what, but it goes back to the order from a judge. Something that I noticed. Everything else is written normal, except for on the very last page. I even read it in my last video. Section number 11 right there. Everything is capitalized and it is underlined. Okay? Parties are advised that incomplete or inadequate information on the preliminary pretrial statement, the statement that I'm going to bring into the pretrial, information that's inadequate will be deemed an admission by the party that the matter is non-complex and may result in the case being set on an expedited trial docket. So the judge is blatantly saying that if I don't fill out my paperwork correctly, we're going to expedite this to a jury trial. That's what I want. So maybe I just might fuck up my paperwork. Technically, what I'll probably do first is I'm going to meet and greet with the other attorneys, find out how they're going to treat me and shit, if they're going to take this serious or they're going to turn it into some fucking facocity of coercion tactics, which I can see them easily doing. Why are you taking us to court? Don't you care about these children? What's wrong with you? How many children you got? How come you can't take care of them? Why can't you get a job and pay like everybody else does? Because I know my rights, you fuckwads. I know, you piece of shits. So, depending upon how that all goes down, I just might request the judge, let's go to fucking jury. But then that's going to be hard. That's a whole different section, too, of the courts. Oh, man, there's like 5 or 6 pages just in this local rules of civil procedure that talk about it. Yeah. Talk about how to select a jury and all that kind of stuff. Apparently, the way it works is that, you know, like if you've ever been on a jury, juries get paid. And it can be anywhere between like $15 a day to be a juror or $5 or, you know, whatever. That comes out of the plaintiff's pocket. I'm pretty sure that's how that works. I would have to pay the 12 jurors. You see how that works? Okay, I'm going to shut this down, everybody. Thanks for hanging out. I know it was kind of long, but yeah. One watching. Okay, well, one watching, that's me. That's me. Because I got it over here on the other screen. Yep. All right, people.